With the advent of Consumer Protection Act and rise in public awareness about standards of professional competence, the appropriateness of their therapeutic and diagnostic methods, there has been an increase in more and more cases of medical negligence against the healthcare providers. Therefore, the healthcare professionals need to update their understanding of the concepts of medical litigation and Consumer Protection Act and its amendments to be on a legally safer side. Today, we have a multifaceted personality, being a thorough leader, medical legal expert, and health right activist, Dr. Nikhil Datar, to conduct a session on consumer awareness and medical litigations. Showing an exemplary commitment towards his patients, even going beyond his professional duty, Sir is well known for managing high-risk pregnancies, complex gynecological surgeries. Trained from the prestigious KEM Hospital, Wadia Hospital, and JJ Hospital, Dr. Datar held senior positions at R. and Cooper Hospital, Nanavati Hospital, and has trained postgraduate students and residents. Dr. Datar has received many fellowships and awards from international organizations for exemplary work in the field of women's health. Commonwealth Professional Fellowship from the UK government, the Austrian American Foundership Fellowship from Austria, Mehmani Watan from the Sindh government of Pakistan are few of them. He received 2 gold medals in his academic career. He is a well-known health rights activist in the country. Dr. Datar has been interviewed by Mr. Amir Khan in the famous show Satyameva Jayate. Dr. Datar is the medical director and senior gynecologist, Cloudnine Hospital, Mumbai, and founder president of Patient Safety Alliance, in an NGO that works on empowering patients and supporting healthcare professionals to prevent medical errors. I welcome you, Dr. Datar, sir. We have with us Dr. Rajiv Yerudikar, sir, who would like to say a few words.
Yes, Nikhil, it's always a pleasure to have you. And I'm so proud that we belong to your fraternity as an obstetrician, though we are no longer practicing. And for the audience, Dr. Nikhil has been closely associated with SYMHEALTH for close to a decade now. And he keeps on coming and lecturing to our students of MBA Hospital Healthcare on medical legal aspects. He's a regular faculty at all SYMHEALTH editions so far. And we have had workshops with him on Patient Safety Alliance, because we do understand that as an obstetrician, he's responsible for safety of more than one patient at a time. Is it enough to comment at this juncture that Dr. Nikhil has been instrumental in revisiting the MTP law, which said that MTP could be carried out only up to 20 weeks. And through his pioneering efforts, he's been managed to convince the Lordship about the need for relook at this time limit of 20 weeks, especially with the advent of 4D sonography, which detects cardiac anomalies only after 24 weeks. So, Nikhil, welcome, and a delight to have you, and all yours.
Thank you very much once again, Rajiv sir, for this kind invitation for SYMHEALTH 2021. For the first time, probably the virtual one. But I'm sure the quality is not going to be different at all. I mean, there is going to be a significant amount of new learning in this conference for me, as well as for all the participants who are attending this conference. Thank you, Abhay sir, for pursuing me and getting me up onto the board for this conference today. And of course, Madam Kazi for her kind words of introduction. So I have approximately about 25 minutes and the topic that I'm going to talk to you about is consumer awareness and medical litigation. And these are few thoughts that I would want to share with you. This is a brief introduction, just gives you a little bit of background and my baggage about from where I come from, what kind of background I come from. So when I keep on changing my hats, on one hand as a practicing doctor and a gynecologist, which is the most sued community amongst doctors, at the same time I changed that hat and suddenly put up a hat as a lawyer, because I also have a degree of law, although I do not really practice law. I use my knowledge of law for the purpose of judicial activism as far as health rights, women's rights are concerned. And hence, with this background, I am going to deal with this particular topic of consumer awareness and medical litigation. And the questions that I am going to actually try and address are going to be as, first of all, is there awareness in our country? If there is an awareness, has it really caused an increase or decrease in the litigations? Is this awareness beneficial or counterproductive? What are exactly consumers aware of? And what should they be aware of? And hence probably we will conclude with way forward, and that is where something which is what I have been a proponent of, the concept that is called as concept of patient safety is what I will be ending my talk on. And I'm sure after that there will be a lot of questions which probably I will like to try and answer. So let's first address the first question. Are consumers aware? And I don't think anybody really needs to know about it, or anybody has any dispute about it. Yes, consumers are definitely getting more and more aware. And whether it is a good thing or a bad thing, I do not know, as to when we call patients as consumers and when we call doctors as service providers, whether it is a good thing or whether it is not so a good thing, or can there be a better thing, is a different dispute, is a different issue of discussion. So I'm not going to get into that. But yes, today patients are consumers by the law of the land, and we have so much of work that is happening. And I found this something very interesting, that there is something called as a national action plan for consumer awareness, which is typically done by the Ministry of Consumer Affairs at the central government and down the line by the state government. And if you actually see this national action plan, and if you really go through it, of course, this is just a title, and if you actually go through that particular document, then you realize that significant amount of work is being done on the basis of consumer awareness. But do you know what is consumer awareness according to them? According to them, consumer awareness primarily means that making consumer aware of where all can you go and litigate, and where all can you kind of take the person to the court of law, and what are the ways and avenues that are available. And more or less, if you see, significant amount of this whole document is being diverted or is being dedicated to this particular concept, which is taking adversarial route for the purpose of consumer protection, or for the purpose of ensuring and establishing consumer rights. Now, we do know that recently the Consumer Protection Act was amended in 2019, and various new things got added. One of them, the most important new thing that got added, was consumer rights. That whole chapter was added. And these were some 6 consumer rights that we spoke about in this particular Consumer Protection Act. And again, if you really look at it, look at that kind of a scenario. 2 or 3 out of these basically are again talking of right of being heard, right of redressal, right of litigation, etc., etc. And when we try to apply that to particularly to medical profession, then we see something else altogether. And when we apply this to a medical profession, okay, it is very difficult to expect that how would a patient be able to understand as to the quality of healthcare and potency and purity, etc. I mean, that can be understood when we talk about a drug or something of that sort. But how do you kind of really quantify or qualify a service that is given by a doctor? And similarly, to be protected, to get protected against marketing of goods and services which are hazardous to life and property. I mean, honestly speaking, healthcare is again a service which potentially has risks. So then how are you going to make peace with these kinds of things when we apply these principles to healthcare is another very big question that we need to keep in our mind while we do respect the patient's rights or consumer rights in particular over here. So has consumer awareness increased litigation? Well, I don't have to say yes or no. I have got this statement coming from none other than Dr. B.C. Gupta, a person who was on the National Consumer Dispute Redressal Commission and ex-secretary of Food and Public Distribution of Government of India, and who says that consumer awareness has definitely given rise to increase in medical negligence cases. And we all echo it. I'm sure that everybody will be on par on that particular opinion. And I also know that there is a significant increase in medical negligence litigation cases, and this is again something which was recently reported by Times of India. 400% increase in the number of litigations that happen against the doctors and the hospitals and the healthcare providers. Now doctors and hospitals should better be called as healthcare providers or healthcare service providers according to the new law, that is the Consumer Protection Act. So there is definitely no doubt that medical negligence cases are on rise. And whether it is good or whether it is bad, let us keep it aside for some time. Let us accept the fact that there is definitely an increase in consumer awareness, and society is increasingly aware that healthcare can also be a subject matter of litigation. So obviously, the number of litigations against healthcare providers is definitely increasing. Now, this has given to a very funny and a very interesting kind of a scenario that most people think that an unanticipated or unaccepted or unthought of outcome in healthcare is not because of the natural consequence of disease, but actually it is the consequence of negligence of the healthcare provider. And this sentence is a very big sentence, and I would really want you to remember this sentence, that when we expect something going wrong during the healthcare, and particularly so during a private healthcare where people are paying money, unless proved otherwise, it is thought that it is because of the negligence of healthcare provider. Gone are the days when people used to think that unexpected outcomes rather happen as natural consequence of the disease, because as a human being, this machine is not understood fully by us, by humans. So healthcare is all about humans, by humans, for humans. And we all know that human being and human body is not a perfect machine. So there is a sea change in the concept of from natural consequence of disease to something which is called as definitely a consequence of negligence from the healthcare provider. So there is a sea change in the ideology of consumers or of patients today, more particularly the educated ones or so-called educated ones who typically use private healthcare services, because it's linked to the monetary gains. It's linked to money at all points of time. And this leads to this particular kind of a situation that is increased in the blame and the shame culture. So here you can see in this cartoon that you have this doctor. There is a patient, probably he has died or he is serious or whatever it is. And this doctor has worked on this patient for a very long period of time. He himself is not able to figure out what has gone wrong, why the things have gone in this particular manner, because no doctor will be interested and no hospital will be interested in having such kind of an outcome in their hands. But this doctor is flummoxed. He doesn't understand what's happening. That's why he's sitting over there. And look at all the other people. So there could be a politician, there could be another doctor, relative, politician, journalist, even cats, dogs, monkeys, donkeys, everybody literally pointing fingers at this particular doctor. And what would they do? They would typically blame that doctor, and down the line they would shame that doctor. Okay, and that is what is called as culture of blaming and shaming. We interestingly see that there is an increased tendency amongst the people in the society to criminalize the medical errors. What does that mean? Going to the police station and filing a case in the police station. Actually, by the Supreme Court, the judges in the Supreme Court, in series of almost all cases of medical negligence that have reached the Supreme Court, have constantly maintained the same position, that indiscriminate prosecution for criminal negligence is counterproductive and does no service or good to the society. This is typically what we are talking of is the healthcare industry or healthcare per se. So there is a very classic sentence that a doctor with a hanging sword on his head will not be expected to perform what he is supposed to be performing. And that's why there has been a continuous disinterest shown by Supreme Court in various cases, whether it is Jacob Matthews to the latest of the latest cases. They have stayed away from putting our prosecution for criminal negligence against doctors unless it's in a rarest of the rare cases. But contrary to that, the common belief that happens today is that whenever things go wrong, people go to the police station, they try to initiate a case. Police in turn refer these matters to government hospitals. Now, government hospitals today have a machinery of having a committee, but there are no guidelines on who should sit on committee and what should be the terms of reference of the committee. And the committee would typically look at it from this perspective. So imagine that today if the committee is set up at JJ Hospital, I'm just taking an example from Mumbai, people at JJ Hospital will look at that particular problem or that particular scenario from the angle of what they would have done at JJ Hospital, which is a tertiary care hospital. And honestly, you might have this case coming from some Mufasal area where primary infrastructure of health itself may be totally different or totally deficient. So what would typically happen? This committee would say that, well, there could be an element of negligence. Now, what the Supreme Court is trying to say is, let the committee decide whether this case is a case of gross negligence or not. On the other hand, the committee, because lack of knowledge, understanding, and lack of framework and training, the committee would say that, well, there could be some element of negligence. The matter comes back to the police. The police say, look, we are not doctors. There is a complaint against you. There is a committee which says that there could be a possibility of medical negligence. So we are filing a case against you. You go, you fight the case. And then typically the whole thing gets started from there. And then 10 years and 20 years of fight. And ultimately matter reaches up to the Supreme Court. And Supreme Court says that, okay, this doesn't seem to be a case fitting for a criminal negligence. So at the end of the day, what has happened? At the end of the day, the patient is unsatisfied, because the patient feels that after a long drawn battle of 10 and 12 years and 20 years, he has got nothing in the hands. And doctors and healthcare professionals are unsatisfied, not because they've got a great judgment which finally absolves them for the responsibility, but the whole process of going through this litigation itself is enough of a trouble, or it's enough of a punishment for a doctor and a healthcare provider. And that's why ultimately criminalization of medical errors does not seem to be a great idea, but that seems to be the most favorite way that patients try to take, or consumers try to take when things go wrong. And in our country, there are so many avenues where a patient can technically go to, or a consumer can technically go to. So first is police and criminal judiciary that I've already spoken, consumer law, civil law, medical council. Now we know that medical council is going to get replaced, but some such kind of a similar mechanism could come. And then you have Human Rights Commission, and then you have Clinical Establishment Act, and then you have so many acts, right? From the Medical Termination of Pregnancy Act, Organ Transplant, PCPNDT, Biomedical Waste Disposal, and many more such kinds of agencies to come. So you can understand the number of avenues where a probable healthcare provider will require to go and fight, or probable avenues which a patient or a consumer would want to use in order to seek justice. Now, out of all these, honestly speaking, it is just the Consumer Protection Act or the consumer courts which are, according to me, the utmost right places where the case should lie, and not at the other places. And if time permits, probably I'll be able to elaborate a little bit more on this particular issue. So let us come to a very crucial and important point, that has litigation been beneficial or has it been counterproductive? To my understanding, litigation is partly definitely beneficial. There is no doubt about it, because till now, what was happening amongst healthcare providers or healthcare in total, whether it is hospitals or clinics or individual doctors or group of doctors, there was no fear at all. There was no fear of being accountable at all. And that is why there was no sense of responsibility to some extent. But the fear of litigation to some extent has instilled that fear of accountability, or instilled that accountability amongst the doctors, and hence to some extent litigation is beneficial. But contrary to that, whether it has really made a change to the quality of healthcare, and has it really improved the quality of healthcare, or let us put it other way around, whether improving quality of healthcare has reduced the incidence of litigation. And here I am going to quote two papers. I'm not quoting papers from India because we are very low on the ladder at this juncture of time, but let's talk about people who are very high on the ladder from the developed country. And here was a scenario where they have tried to assess this. A national study was done, and they said that tort litigation does not increase the quality of performance of nursing homes, or as a matter of fact, it may decrease a little bit of such kind of a thing. So they tried to say that litigation or avenue of litigation being available has not really given rise to a lot of importance or improvement to the quality. And similarly, there was this another paper which was published way back in 2011 in New England Journal of Medicine, which is a very reputed journal, where they tried to find out the relation between the quality of care and negligence per se. And they found out that best performing nursing homes, are sued only marginally less than worst performing ones. So the chance of you getting sued just does not significantly go down. And if that is the case, then why should there be a reason, or what would be an incentive for nursing homes or hospitals or doctors or healthcare providers to go into quality of care? So if by doing or adopting great quality of care, if there is not going to be any protection that is going to come in, then what could be an incentive for them to do that? And that was the question which was raised in this particular paper. So I am just again saying that I do believe that there is some specific role that is played by the fear of litigation in order to improve the accountability. I'm not getting into the quality debate at this juncture of time, but it has definitely improved quality. That's my personal opinion. But I'm at the same time giving you the data which is being showed in the evidence part of it. And we are a organization, Symbiosis, which will go by evidence and by data. So that's why these two papers are going to be crucial and important. And collectively, what has happened is that this has ultimately given rise to something which is called as defensive medicine or defensive practice or defensive healthcare, and which is definitely a bane to the healthcare. So 83% of the physicians today feel that they are practicing defensive medicine. And what do you mean by defensive medicine? It means that there's an increase in the diagnostic test, it increases the cost of care. A number of people who are willing to undertake treatment which involves some serious risks will go down. Well, every stakeholder, including doctors, for him or her, safety first should be the motto, but it should not be safety first is equal to safety and only safety. Okay, so that should not be really a motto. But unfortunately, we are moving from safety first to safety only kind of a scenario. Ultimately, this causes increase in the healthcare cost, and it in fact increases the dissatisfaction amongst the patients. And the days are not very far that you will have this kind of a scenario, the way we see in mutual funds, that there is a standard declaration that mutual fund investments are subject to market risk. In a similar way, there will be a disclaimer, healthcare is a subject matter of risk, and you want to take it, you take it. You don't want to, if you want to leave it, you leave it. And we don't want a doctor who says this kind of a stuff to us. We want a doctor who is going to be a friend, philosopher, guide, a person to look up to, a person where the whole family puts its trust, not a blind trust, but puts its trust. That's what is the healthcare all about. And that's what really we need to take our healthcare to. But contrary to that, this is where it seems to be leading us. So this is a very interesting and a very important thing that I found somewhere. And that's why this quote, that it is all about balance. And what they mean by balance, balance means stability found at the center of acceptance. So you have to accept, but there has to be a center also of acceptance. Of course, I mean, for an elephant, as shown in this slide, such a huge elephant to get himself balanced or itself balanced on a small ball, not a difficult thing, not an easy thing to do, but that's still possible. That is still doable. And if elephant can be taught, why can't the society not be taught about being rational, about being balanced, about being truthful, and about being accepting the facts of the life? So let us now talk about what should consumers actually be aware of. So today, consumers are definitely aware that healthcare is a subject matter of litigation, no doubt about it. But are they really aware of these facts, that why do medical errors occur? How consumers can help in reducing medical errors? What is really called as a culture of fair blame? What are the rights and, most importantly, responsibilities of patients and all the stakeholders? So I would not want to say that it should be only about patients. Actually, I would like to say it should be patients' rights and doctors' responsibilities, or healthcare's responsibility. And similarly, healthcare professionals or providers' rights and patients' responsibilities. So it has to be mutual give and take kind of a scenario. So our Consumer Protection Act at the moment of time is only lopsided, talking about rights, but not talking about the responsibilities also. More so particularly when it comes to healthcare. And why I'm saying particular to healthcare, the next few slides will tell us about it. And whether the patients know about the right redressal mechanism when it comes to a potential, possible, doubtful, untoward outcome, or a possible medical legal case or a medical negligence case. According to the World Health Organization, the fifth common cause because of which deaths in the world happen are unintended medical errors. International norms say that 10% patients suffer medical harm when they go to a hospital. Ashish Jha from Harvard University reported 5.2 million medical injuries per year in India, just about 2 or 3 years back in his famous paper. Data across the world says, and this is a very interesting slide, because in this slide, they have compared various so-called hazardous industries and what is the chance of an untoward incident happening. So you have nuclear power plants, you have railways, you have airlines, you have chemical manufacturing industries too. You have bungee jumping, you have got mountain climbing, so on and so forth. Now, contrary to common belief, it is said that nuclear power plant or a scheduled airlines is considered to be ultra safe, where the chance of untoward outcome or incidence is very less, between 1 in 1 million to 1 in 10 million. Whereas such kind of a chance happening in a bungee jumping or a mountain climbing is supposed to be 1 in 10 to 1 in 100. And that's why bungee jumping is considered as a hazardous sport. Lots of people will think 120 times before going in for bungee jumping. Interestingly and surprisingly, the data shows that healthcare is as hazardous as mountain climbing or bungee jumping. The big difference between bungee jumping and healthcare is you have a choice whether you want to undertake bungee jumping or no. But as far as healthcare is concerned, you don't have a choice, because each one of us will require healthcare at some point of time. And hence, when we say that healthcare is as hazardous as bungee jumping, one can understand the real magnitude of the problem that we are facing. And this was exactly what was faced by this gentleman called Lucian Leap. And he did this kind of a study way back, almost like 20 years back or 30 years back, where he pulled out 30,000 records from the hospital, from this Harvard medical practice study. And he found out that the incidence of adverse event was 3.7%. As a matter of fact, 50% of these adverse events were actually preventable. Very interestingly and surprisingly, only 1% could fulfill the real test or criteria for it to be called as negligence. You can understand this. Now, this is what it means, that on one hand, 50% of adverse events were preventable, but only 1% were actually something where you can really attribute to negligence. So significant proportion of adverse events are not due to negligence. That is what is the meaning of this particular study. And then down the line, I mean, a lot of studies, initially every change that happens always happens to begin with non-acceptance, and then slowly the whole world accepts these kinds of things. And that's exactly what happened to Lucian Leap. Don Berwick, the leader as far as patient safety ideology is concerned, has said that many people in the healthcare profession and in general public still believe that mistakes in medical care are episodes of individual failure, and that most errors occur as a result of someone not doing his or her job properly. And this is exactly why you tend to blame people when the things go wrong. Whereas the World Alliance for Patient Safety, and I'm going to talk about this a little bit later, and I'm not going to get into the details, but they have done a real in-depth analysis. I would rather call it as anatomy, physiology, and biochemistry study of medical errors. And they now come to a conclusion that significant amount of medical errors are because of human design. Lots of it is also to do with the system or the organizational factors, and some are circumstances which are patient-related factors. I'm not getting into the details of it because that's not really the topic of our today's discussion. But let me give you a glimpse of what is called as human factor or individual factor. I want all of you all to read this particular slide, and you will be amazed and surprised that all of you all will be able to read all the words which are written in this particular slide. Now imagine, there is not a single word which is written correctly over here. All spellings are jumbled up, all spellings are wrong. But in spite of that, all of us human beings are able to correctly read every word that is written over here. And do you know why does that happen? That happens because we are human beings. Computer will not be able to do this. And what do you mean by being human? Being human means that our brain is kind of programmed in such a manner that we process the word together, and we do not process it as O-L-N-Y. We look at the word and we interpret O. The word is O-N-L-Y. And this is what happens at 2 o'clock in the night in a busy ICU department, where a nurse is trying to resuscitate a patient, and sound and drugs which are same sounding spelling wise, adrenaline and atropine, which have completely diagonally opposite effects. Atropine is not picked up, but adrenaline is picked up, and adrenaline is given, and you'll end up with a major complication with the patient. And in retrospect, you ask that nurse or that doctor, how could you make such a big blunder? How could you take atropine in your hand, or how could you take adrenaline in your hand when you were supposed to give atropine? And we label something which is called as culpability to such kind of errors. So we have almost kind of stopped believing the fact that to err is human, and we consider for every smallest possible thing that there is somebody who is culpable. But the fact of life is that even errors have different degrees. It starts from deficiency, then error, then mistake, then civil negligence, and then criminal negligence. But we collectively as society have forgotten that there is a difference between these things and culpability in general. And that is why we try to hold somebody responsible or culpable when the things go wrong. And that's why the whole blame culture comes into the picture. Now, actually, when the things go wrong, what are patients really wanting to do? So they are really wanting to take the legal recourse for what reasons? They want a correction to the deficient service. They want an apology. They want an explanation. They want to enforce some kind of an accountability. They want to have compensation. And they obviously want to bring out their dissatisfaction or their anger. And they, in fact, want a very, very good redressal mechanism that can give them some kind of a solace. But in fact, what are we doing by the system, which is an adversarial system in our country at large or in our society? So are medical laws or practices conducive for patient safety? Well, honest answer is no, they are not conducive. Why is that so? The reason is very simple. Now imagine today that there is a patient who says that, well, doctor, I do understand that you have made an error, but look, because of this kind of an error, this is what is the loss that I have had to suffer. And because of that, I'm just seeking some kind of compensation. I'm not interested in calling you as a bad apple or, somebody who is incompetent or something of that sort. I just need some kind of a compensation. Will his plea be heard by the court? Answer is no. Why? Because our system is adversarial. Unless and until the patient proves the doctor to be negligent or hospital to be negligent, only then compensation will be given to the patient. So it is necessary for the patient to mandatorily blame the healthcare provider and doctor or the hospital to mandatorily refute that kind of a negligence. And ultimately, at the end of the day, will the patient get compensation? Well, it's going to be much more harder for the patient to get compensated. Our system does not encourage alternate dispute redressal mechanism. We were very hopeful that the changed, amended Consumer Protection Act will encourage it. Well, they have encouraged it to a great extent, but they have excluded medical services, particularly when it happens with death or when it happens with serious injuries. They have categorically said that these cases should not go to alternate dispute redressal mechanism. And when we have in medical cases, when we have such kind of major problems or unintended or such kind of injuries, medical injuries, they are most of them of very great significance, or they do cause a lot of disturbance in the quality of life of the person, but they have been kept outside the alternate dispute redressal mechanism. And then we have classical examples of our acts which themselves do not keep up with time. The Medical Termination of Pregnancy Act is a classic example. As Rajiv sir said, it was my case, Dr. Nikhil Datar versus Union of India, way back from 2008, that has ultimately, after 13 years, has led to amendment to the Medical Termination of Pregnancy Act. But how many such people will have to fight for how many such number of years to make a change and bring laws of the lands which are in tandem with the real requirement of the society? That's what is really a question. So our medical laws are not really conducive to patient safety. And that's why typically what happens is that when things go wrong, we know that victims are definitely the patients and the relatives, because they are traumatized, they have a lot of suffering, they do have a lot of financial kind of a problem. There is a lot of uncertainty about what would happen, whether they would really get any justice. That's because we have a very poor redressal mechanism. I told you about that. But on the other hand, we also create second victims, which are the doctors and the healthcare providers. So typically a doctor would go through a sense of shock. He would go through a sense of resentment. There could be attacks which are physical or reputational. There could be police, there could be media, there could be arrest, there could be all these kinds of things. And hence the doctor is also going to be onto a defensive kind of a mechanism. Well, in 2009, I had a chance of going to the WHO, World Health Organization, as a Commonwealth Professional Fellow. I had a chance of working at the World Alliance for Patient Safety, and that is where I actually heard, read, and started believing in this concept, which is called as concept of patient safety. Now, I must clarify that the word patient safety, as defined by WHO, is safety of patients and its healthcare providers. So it is not a lopsided concept, because a lot of people in India think that patient safety is about patients, not about healthcare providers. It's an over-encompassing kind of or overarching kind of a concept. It means safety of all stakeholders in the healthcare. That is what typically it means. So typically, WHO strategy talks about error reporting and learning. Now, if you want error reporting and learning to happen, then what you require to do is that you require to have a patient safety culture. This is a culture where errors do not require to be hidden. As a matter of fact, error can be disclosed openly, because there will be so much of learning from these errors that it will bring in more sense of safety and more sense of risk management. And hence, in the words of patient safety dictionary, medical errors have to be termed as patient safety incidents, negligence has to be defined as deficiency, and fixing the blame has to be, as a matter of fact, no blame compensation. So there is absolutely no doubt that the person who is a victim needs to be compensated, but one does not require to fix a blame for this kind of a purpose. So that's why a few years back, I started this small initiative called Patient Safety Alliance. And this is a website of Patient Safety Alliance where we try to empower patients as well as healthcare professionals in terms of how to make their practices safer, just, and fair for all the stakeholders in this particular country and society at large. Well, I would like to end with this last quote, which says that society accepts change in technology very easily, but it is very hard for the society to accept a change in the ideology. This is a small beginning that we have made, and Dr. Rajiv and Symbiosis has been very strongly supportive to this particular ideology. This kind of an ideology is taken up to the people who are at the helm of affairs, politicians, policymakers, etc. And we have a mechanism which ultimately brings a fair and just deal for everybody, consumers, healthcare providers, patients, because ultimately we have to believe, and it's a truth and a fact, that whether you are a doctor or a patient, each one of us is patient for life. We perform as doctors for a very small period of time during our professional career, but before becoming a doctor, we were patients, and after finishing being a doctor, we will continue to be patient. So being patient is eternal, and hence patient safety is what matters the most. Thank you, ladies and gentlemen. Thank you once again.
Thank you, sir. We have one question our in-house advocate Milind Salunke sir would be asking you. So I'll hand it over to you.
Sir, good afternoon. It was very much indeed to listen you. It was very informative session. While deciding the case laws called as very famous case laws Bhagwati, it's in respect of the evolving the basic structure theory by Honorable Supreme Court. Likewise, the Symbiosis has evolved idea of basic structure involving Dr. Nikhil Datar and in each and every conference every year. So apart from this, so many questions I have got from the students. The one question, would you please throw light on how we can differentiate between criminal and civil negligence?
Okay, it's a very good question actually. And to be very honest with you, it's literally like a very gray kind of an area. By far and large, what the Supreme Court has defined as criminal negligence is rarest of the rarest incidences, whereby no throw of imagination one could have done something of that sort. So to give you an example, something like a doctor who is giving a lethal dose of a medicine, okay, to a patient with an intention of causing death of that person. Or let us say a sexual abuse, okay, done by a doctor in a hospital. So these could be few of the examples of criminal negligence. And as Sir and Dr. Milind Salunke is over here, we in criminal negligence or criminal law believe in something which is called as mens rea. That means what is the intention? Now, if you look at it in that particular manner, then what would be the intention of the doctor to cause harm to the patient? There is no intention, really speaking. As a matter of fact, every doctor would very happily want patient to go home because that's where he is going to be paid his charges, or hospital is going to get his charges. So by that standard, unless there is such kind of a criminal intention in the mind of the healthcare provider that it almost amounts to criminality, that only should be the case of criminal negligence. So criminal negligence is expected to be rarest of the rare events, and that's why Supreme Court has always constantly said to stay away from criminal negligence, but to encourage civil litigation or compensatory mechanism. And I would go one step beyond that. It should be a blame-free compensation mechanism. So I hope that I am able to clarify it in the shortest possible time which I could do so.
Certainly.
Thank you so much, sir.